The 2020 census results revealed that Black populations were increasing while white populations were decreasing, including in key jurisdictions where the Legal Defense Fund has worked for decades. And the data was really clear. The population growth in this country over the last decade has been driven by voters of color, and new electoral maps should reflect greater electoral opportunities for Black voters and other voters of color. But with this being the first redistricting cycle without preclearance, a predictable and unfortunate pattern emerged. So states were evading their constitutional and statutory duties when they engaged in post-2020 census map drawing. And as background, a little over 12 years ago, in 2013, the US Supreme Court handed down a ruling in Shelby County versus Holder that severely weakened a crucial section of the Voting Rights Act. And so by declaring that preclearance framework unconstitutional, which was a framework that identified which states, which localities with defined histories of racial discrimination in elections were required to obtain approval before implementing any proposed voting process changes, including new maps. So with that, the court opened the door for a bevy of suppressive voting laws and racial vote dilution tactics that have severely harmed Black voters in this country. And preclearance was an enormously successful requirement and arguably one of the most transformative provisions of the most successful civil rights law in American history. And discriminatory voter suppression laws were stopped before they even began. And eligible Black voters experienced really unprecedented access to the ballot box. And now for this redistricting cycle, the first without these full protections, this meant just as a practical matter that discriminatory maps proposed by previously covered states would not be scrutinized either by the Department of Justice or a three-judge panel in the District Court of DC before they were enacted.